the appointment, the 5.5.
Yes, sir.
Anywhere you want to be in there. Does that mean you don't have one at this point, or you?
Nope.
Okay. All right, so I will go to the next point, which is 6, allowing Ms. Hamilton to improperly apply for and receive retroactive appointment, retroactive fees in violation of the statutes. What are statutes?
Those are orders, administrative orders.
Administrative orders.
And
What is the significance in your experience of violating those orders?
Significance?
Yeah, I mean, what is their authority? What is a better way to say that? What have you run into? I mean,
Well,
these are typically what I would guess would be the standing orders for any judge in the courts under name. And
yes,
they would
they're
be
standing orders.
required to abide by them on some level, and there would be a penalty or something if they didn't, and whatever not. I mean,
Right.
Yeah.
Well, you're aware
Something
that
like
rules of the court can be waived. You're aware of that.
Yes.
This is not a rule of the court. This is an administrative order. It cannot be waived. That's a major difference. So it's an administrative order of the court. So you have all the various family division courts. You have the superior courts all across the state. The administrative office of the courts has determined that this order must be followed in all the courts across the state, all the superior courts, for instance, or all the family division courts. So they don't have the option of waiving these. There's no option of doing that. When I brought this up to Judge Arnold's attention, he said, I've waived that. And I said, you can't waive an order, an administrative order of the court. Well, yes, I can. So we're going to get in this, yes, I can, no, you can argument. I'm not going to win, of course. I'm not going to win.
Well, that's an interesting thing that you have that argument, that discussion with them. Representative, I think Lambert still. You can. I'd like to let him finish and I'll come back.
Go. Yeah.
All right, I was working. Okay.
So my question was, haven't I heard people in the halls around here saying, actually wouldn't know the answer to that, are there discussions amongst the public as to whether or not the family courts are obligated to follow all of the administrative rules, because the judges seem to think, or administrative orders, because the judges seem to think they don't have to? Where's the clear line of distinction that someone has said family courts are within the jurisdiction of the Supreme Court and must follow all administrative orders? Because I've heard people say that they don't.
I haven't heard that. You talk to, I'm sure, worthier people than I am about that, but
you're telling me that they don't follow it, and the judges say that they can waive it.
That's right.
So I'm saying
Yeah,
they,
Well,
in practice.
But in practice, again, this is my experience only in Cheshire Superior Court, they don't even follow statutes. Statutes, I mean, nothing is followed in the court. And you can think, well, it's a court of equity, they can waive the rules, but that's what happens in a court of equity. They don't have to follow anything because it's not a court of law. So the orders, the administrative orders don't have to be followed, statutes don't have to be followed. And then you have examples of what happens here. We can just put this woman on the case who's not appointed. We'll just say she's appointed, and we'll give her $7,000 to make her day better, and we'll do all these things. It has nothing to do with the law. It has nothing to do with orders. We're just going to do it as we go along. And this happens.
My experience with the, when we take the point, we've heard it many times. I'm not a big dismissive of that. Representative, but the question of waiving, I understand that in court, a waive is a formal activity.
It is.
Was it formally waived?
That's right. In order, I understand.
So I formally waive the SCAO rules.
If it was a rule, there has to be a showing of good cause. And you have to show good cause. You have to do a written instrument.
And so you were looking for that and never got it, I take it.
It was never even asserted.
He just said, I waived that.
That's right.
He said I waived it, but we have no documents that he waived it. You never saw. You requested.
My attorney talked with him in chambers, Michael Walsh, and he brought this up to Judge Arnold. They had an hour conversation with Judy Hamilton, opposing counsel Kathleen O'Donnell, and my attorney said, he just raised his hand and says, I waived it. And my attorney said, I'd like to see the waiver. I waived it. That's all you need to know. I waived it. I'd like to know when, how, what, why. That's all you need to know. I'm the judge here. That's all you need. And that is the difficulty here.
Back to you, Representative Lambert, followed by you.
Sorry. I've concluded from statements of the representatives and yourself that we have in fact a court, which is a court of equity, that appears to be, according to you, I believe, someone said a moment ago, they're waiving the laws, they're waiving the statutes, they're waiving the procedures, they're waiving all kinds of things, and they're not following the rules. And yet you complain that they threaten to put you in jail. Are you telling me that all of these people who can waive all of these rules and all of these procedures can actually have you incarcerated?
Absolutely. At a whim. At a whim. If I may,
You got into a point? You got into another point?
may I speak on that?
Yeah.
There's a recent Supreme Court decision which waived or provides quasi-absolute judicial immunity to guardians of the light. And so what happens is the same situation goes on now. Rather than having a judge who can waive the rules, we have a de facto situation in which guardians ad litem can rove about the state with almost absolute judicial immunity to anything they say, anything they do. They can make any report to the court about anything. It is one step away from having these agents of the court who have almost complete immunity to do anything they want. This woman defrauded me out of tens of thousands of dollars. She could do that to anyone else in the future if she's allowed to stay on in her capacity, or other people in that same capacity.
Representative Lambert, a follow-up?
A follow-up on this point. As I read the Supreme Court's decision, quasi-judicial immunity, or absolute quasi-judicial immunity for guardians ad litem applies whether or not there was malice or anything else. If I understood the Supreme Court ruling properly, this lady could have shot you, and there's not a damn thing a court in the state of New Hampshire could have done. Do I misunderstand that Supreme Court ruling?
That is correct. That is correct.
Representative Abar.
Thank you, Mr. Chair. Just a point that I actually have talked with Mr. Miller regarding the Rule 1.2 and the rules. And originally,